judicial review application. Or judicial review application. My lords, exhibits attached to our judicial review. My lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondents, National Democratic Congress. My lord, it's in the supplement. Yes, so, my lord, I'll be very specific. I have a supplement.
See, the problem you have created for us, some of the exhibits, I have them as B, and my other have it as A or C. This is the problem you have created for us.
My lord, I'm sorry. I'm sorry about that.
Unlike the other parties who have actually flagged.
My lord, that should be exhibit D in our supplement. It's the application for judicial review by the NDC.
Yes, you make the point and let's see if it will help us locate
Okay,
the
okay. My lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My lord, they were before him. In fact, I stood up. Yes. I stood up. Yes, my lord. That's the unique thing. I stood up and brought to his attention that, my lord, pending before you this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
My lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day.
Okay.
So I stood on my feet and drew my lord's attention that, my lord, these are declarations with video evidence. So consider my application first. He ignored it. And so, my lord, with the greatest respect,
I lost respect.
Yes, Counsel.
You see, some of the facts being heard on this court are indeed erroneous. Yeah, erroneous. And I think it's fair that I put them in context.
Okay.
The process he filed.
Counsel, you can raise
No,
this.
just hold on.
Please. What he filed was not before the judge. It was not before the judge. It was not on the docket. He was not said.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the one
application?
The first application, the one they filed on 16th.
The one they filed.
On 16th.
Yes, that was determined by the court on the same day, yes.
Okay.
That's
No, that's just
the
the
joint that he had filed.
No, we're talking about the first application. Okay. So, Mr. Tamaklo,
Yes.
continue.
So, my lord, at the time my lord considered the mandamus application, he had before him video evidence. And in fact, when I brought it to the attention of my lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it, and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared. And that at the time he was considering the mandamus, he knew that that would definitely affect their rights. My Lord, on the grounds of bias, on the grounds of bias, is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he's done hearing, our application for judicial review would have become moot. Manifest bias. My Lord, 2. The mandamus application, in one breath, my Lord says, our gender, on page 2, offense, rule 14 of CI 47. However, my lords, the mandamus application that was granted, with respect, had no statement of case attached. So in one breath, my Lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My Lord, without the statement of case, the court's jurisdiction for the mandamus was not properly even invoked. And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
My Lord, Order 55 Rule 6. 2.
It says what?
6.2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such numbers, such copies of the applicant's statement of case. Mandatory. And my lords, this court, in the case of my lords, in the case of Ni, because my Lord said what's the authority?
Of course.
Yes, yes. My Lord, in the case of Ni Okaija the third, and Ni Tete Ahinkwa the second, and Thomas Okai, civil appeal number J4 2009, dated 29th April 2010. His Lordship Justice Badegbe had this to say, that when J4/20/2009, it was dated 29th April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu-Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2017, dated 1st May 2018. It was held.
Council 57 or 67?
57. Eniegba JSC, as it then was, had this to say. A court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a mandamus application, but the rule says, at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Tamaklu,
My Lord.
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my Lord, I take it that you are willing to
raised
waive
it,
this one.
and we said that, look,
No,
we
my
are
Lord,
waiving it.
no, my Lord, when you waived, it was on record as having waived it.
So it's,
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gets on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record.
Yes.
My Lord,
But does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you
yes, my Lord.
that the EC before the High Court was not opposed to the application?
My Lord,
Therefore, the waiver even started with the EC.
No, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
Party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
Yes.
Yes, my Lord, what we are basically saying is to just draw this court's attention to the nature of the bias. In one breath, he holds us strictly to the rule. And my Lord, that is even denied. The gender application had a certificate of exhibit with the greatest respect attached to it. Yeah. Yes, yes, yes. I'm not afraid there was no exhibit. Yes. So, my Lord, I'll just read the ruling.
Oh, no. Which one? On your non-compliance with the rules?
No, the issue of the manifest bias.
Okay.
My Lord, Exhibit B series, Ex-Parte are not on prey.
Yes.
My Lord, there was no exhibit attached. So the issue of certificate of exhibit does not even arise. But my Lord said we had offended the rule.
Okay.
My Lord, 2, Ex-Parte Nana Equia Owusu Efriye. That one, we attached a video recording of the declaration, and there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. My Lord, I want to bring to your attention the decision of this court in the Republic versus High Court, Bogatanga. Ex-Parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said, Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because
Proceed.
Because the applicant parties, at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. But that is far-fetched. Because the application for judicial review, which had the video recordings of those declarations, was duly served to respondents. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. The EC knew. And that is exactly the decision of the Supreme Court in Ex-Parte Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituency.
Is stating that knowledge and information, didn't he?
Making respect, my Lord.
Yes.
One, he does not attach any official record or official document to the deposition, or a police report of the returning officers detailing the so-called
Yes,
arrest or
so
fraud.
that weakens the weight.
Very well.
I don't think we...
No, my Lord, I just want to bring it to you
Okay.
that those depositions should not be.
May I respond to?
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter.
Very
But you can't, don't say we should expunge it.
My Lord,
Yeah.
the respondents say they had already done the collation. And so what is the point, you considering our application? My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenufo and Gary Nimakun, where there was a pending injunction application against the Electoral Commission. That it, my Lord,
My Lord, so far, various applications have been made in this court in the course of submissions which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel, if he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the need. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel.
Please restrict yourself to your affidavit and let's go on.
Yeah.
yes, my Lord. So,
We don't
my
have
Lord,
the whole
no,
day.
my Lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us 2 days.
My Lord,
to come
this
to-
is not before the court.
Okay. So you haven't deposed. You haven't deposed.
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord,
You were addressing us on what you said is the argument that
Yes.
the declaration has been done already. So address
my
us
Lord,
on that.
our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this basis that we make this prayer. Yeah, so, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed.
Yes.
My Lord, with the greatest respect, the agenda application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about, what you are alleging, my Lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the joinder was heard. A joinder which was not on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. I'm saying that we were not heard.
So it's different from saying that the
Very
judge
well.
was.
We were not heard. My Lord, nowhere in my Lord's ruling did he hear a say with respect that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my Lord, and that is what we are
So it's not the joinder. He had before him an application for mandamus. And their case is that when you appeared, he heard you on the application for mandamus.
No, my Lord.
No, I'm trying to get you to understand their case because you are misrepresenting their case.
Very well. So, my Lord, the point we are making is that we were never heard on the application for mandamus.
Mr. Tomekulu,
Because first we were praying that we'll first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My Lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu, a 3 year.
My Lord, I want to just locate my.
I believe it's yours as exhibit B series.
Okay.
No.
Okay. Yes.
You found that?
Yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but it's fine. But the one in respect of Nana Akua Owusu, a 3 year.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
can you read it?
Yes. The application on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kuju Ebiji Tamaklo to the effect that the winner of this constituency has been declared, and he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending tender and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
No, but you were not a party to the application. Perhaps that was why he decided to describe you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my lord,
you wind up.
My lord, on this basis, so my lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My lord, within this context, a failure to do that, my lord, will be a serious affront to the rule of law, constitutional requirements, and the right to head the other party. The Supreme Court, and my lord, I conclude here, the Republic versus Court of Appeal, Anthony Tomford, Ex-Parte Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atiguba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Atheron Party rule involved. That Odi Atheron Party rule has been elevated to constitutional pedestal, and this breach has constitutional consequence. My lord, and said breaches void the act in question. My lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Mr. Justin Amenuvo, counsel for the first interested party. Can we hear you?
Yes, my lords. My lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court telling the court what injury they have suffered by General Decision 13, just saying that Electoral Commission, go and perform and complete your constitutional duty. None.
In the individual applicants?
Yes, my lord. There's none before you. They have not deposed to any.
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. It's an artificial person. These are individuals. The first applicant will not go to parliament. It are individuals. They are before you. They have not said anything. My Lord. Well, he said he has sponsored. Let the sponsoree. It's the sponsorees who go into parliament, not the sponsorer. My Lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother, now retired Justice Badegbe, delivered a ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my Lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read. Of CI 47, my Lords. No proceedings shall be defeated by reason of misjoinder or non-joinder of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My Lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
Why do I not the writ? Why do you?
No, that's why I use the word even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore Cesurera should lie. Respectfully submitted. Thank you.
Oh, Counsel.
Right.
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my Lord.
Yakubu, the decision was that if the party in an election will be affected.
No.
No,
my Lord, the order in Hawa Yakubu was directed at her, an injunction placed. But in this particular matter, it doesn't apply on all four simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my Lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my Lord. And then also, one last thing, now that you have brought it up, my Lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just.
So this is Channel 1 Television. You're watching us. We are broadcasting from number 5 Ola Hansen Lane at Tesano in Accra. My name is Umaru Sandabado. So
I'm not able to. It is an appeal. Let me give you.
Counsel, take your time.
My Lord, it's an application filed. Oh, my Lord. Well, my Lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my Lord, to wrap up, none of the applicants before the court have made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimaku.
My lords, we are also opposed to this application. We filed a plea opposition in the statement of case on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. My lords, my other friend has hinged this application on a motion for joinder, which was not on the docket of the court, which all parties to the action were not served with a said application at the time when we were dealing with the mandamus application. My Lord, we submit. The application for joinder was indeed a non-starter. That is because, my lords, there are specific rules dealing with mandamus application under CR 47. Specific rules. Joinder is not one of them, one of those. And my lords, in Boifio, this is NTS for properties. Boifio, this NTS for properties. 1996, 97, held. That the law was clear that where an enactment had prescribed a special procedure by which something was to be done, it was that procedure alone that was to be followed. My lords, Order 55, Rule 5.2, has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. I was from a court, the 4.5.2. The court may order that notice, and it may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion at the line, it is desirable that a person should be given notice. It is a rule, my lords. It is a rule, not by joint application. And my lords, this is a discretion which a court has to exercise
It's a discretion. It's a discretion. And if a court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, Ex-Parte 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yeah. The clear thinking of this court is that.
What page are you quoting?
Page 619. 619.
Yes.
The clear thinking of this court is that House of Jurisdiction and Article 132 related to Constitution should be exercised only, and the word underlined only, in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the jurisdiction a complete nullity. My lord, if I may even look, if you may
now, I get the point, but you see, you would agree that the Ex-Parte Chachukikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the order or terrain pattern. So, yes, if it comes to error of law, your point holds. But also address the area of the failure to observe the order or terrain pattern rule.
Yes.
You have argued it, but I think you should expatiate on it.
My lord, we submit that a non-party to a suit cannot complain. That his right to fair hearing has been breached. In this case, my lord, I saw the Republic versus High Court, Accra. High Court, Accra. Ex-Parte, Danso, and others. MPP, EC, interested parties. 2015, 2016, 1 LGLR at page 760. 760. 1 Supreme Court of Ghana Law report at page 760. Holding 1. This court held in dismissing application for judicial review as follows. That in spite of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak.
But there are several decisions. Republic versus Collegono Magistrate, Ex-Parte Amponsa, which has been cited by Amenuvo. They said that as for sexual rights, their public law reliefs, you don't have to be a party. And then we have
It's about capacity. It is an order
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex-Parte, Adavali, and so many other cases.
Yes,
but make your point.
Yes, so the point we are making is very simple. The High Court only made an order directed at a public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, which the court made for the EC, the first to go and collate and declare who has won or who has lost, my Lord, it's a public function. It's a public function. How does that order to go and collate and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
Yeah, my Lord, Exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation
D9,
sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election result summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the collation and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My Lord, with all respect.
Because they have a right, even at the administrative level, to object.
Yes, my Lord, under the CI 127.
Yes.
If a party decides not to participate in the process,
yes,
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There's nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the collation, the other contestants will have an interest.
My Lord, with all respect to you, the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted and you want to challenge the result of an election petition. Petition, my Lord, with respect. At the time when the court was making an order for Madam's application, this exercise I don't know if effective. But now, personally,
I'm just trying to say that what the applicants are saying is that they stood to be affected, and you are saying that they would not be affected. Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Benubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you, but it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my Lord, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein where not factored in
Okay. All
at
right.
the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed.
Mr.
Mervo, if you
my
want,
loss,
Mr.
my loss,
Yeah.
events.
That's right. No, just one point. Mr. Mervo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you.
Ma'am.
You know, the D10, the form doesn't contain the portion for stating the reason why you will
Yes, my lord. I
So it's of interest to you.
Yes, my lord.
Okay, thank you. Yeah, Mr. Gary.
Yes, my lord. So, my lord, clearly. The point I'm making is that if there's public elections have been conducted in all polling centers, result declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should a problem, my lord? Why should a problem? Why should it,
we don't
why should the EC not be allowed to do his work? So, my lord, the point that we are making, granted without even admitting that the application for joinder, which we have said, my lord, is a non-starter, because the rules don't provide for joinder applications. If the judge has been aired, granted without admitting, the judge has been aired, the recourse of the petition of the applicant is appeal, not judicial review. And the judge should arrive, as you have to do before you this morning. My lords, again, my little friend make a point about where's the rules book? About we not filing a statement of case. Thereby making the application not right for hearing, and the judge being biased. We refer my laws to Order 55, Rule 6, two, 3, of CI 47. That within 14 days after filing this application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments, relevant cases he wishes the court to consider. My lord, is the registrar. The registrar. Now, if the applicant does not file a statement of case within a time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing of the statement of case deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desired to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work declare the winner, declare the loser, and the matter is foreclosed.
Oh,
it's foreclosed.
If that were the law, the illegality will persist forever. So I'd like your other arguments, but as for foreclose, your other arguments you have answered substantive.
An order by a court to proceed to perform a constitutional essential function.
If it's set aside, that would be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one,
yes.
Yeah.
Further, my lords, it is not the applicants, that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, there will not have been an NDC party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Ekwia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Ekwia Owusu. Yeah, be serious. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
As we be serious, the application on the face of it is not different, notwithstanding the submission of a friend of the court in the person of Godwin Edugi Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she's saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos. Alos.
Yeah, you were there, so probably you.
Yes, alos. The application, my friend, far before you. If you look at all the exhibits which they have filed, my lords, you realize, what is all this? My lords, you realize that they have not, or they did not, what is this? They did not, no, our application, our Philip, what is it? Yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, that, we hadn't reached that stage. And because
then direct me properly.
No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My lords, the bottom line is that, let's say, even there was even a declaration in court, but there was none in court. If the collation is done and will be confirmed that indeed you have won.
No. The judge said it will not affect her.
No.
Anyway, it is not your writing. It's because you were there, that's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is so.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then...
So, my lords, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which is the jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice.